Thank you. All right. Is everybody ready? Let's go ahead and get started. No, I can't. I'm just not that guy. Everybody can take their time sitting down. All right. Everybody sit down. Thank you. Perfect. Okay. Great, everybody's back. All right, so following that elder abuse presentation, I think we're going to talk a little bit more about elder abuse. So I'm going to be talking today about, now it's not working. What did I do? Oh, there it is. Okay, I'm going to be talking today about diminished capacity in cases of elder abuse, which is a topic for those of you that are new, you're going to be dealing with quite a bit. So my name is Matthew Schwimmer. I'm an attorney at West Tennessee Legal Services in Jackson, Tennessee. At West Tennessee Legal Services, I'm the Equal Justice Works Elder Abuse Fellow. So I've been doing this for about a year and a half and have a little bit of insight, but if there's anything anybody would like to add at any point, I'm more than happy to have you do that, and please ask questions if you have them. So you've got a role today. Number one, you have those sheets that you picked up on the way in. What you're gonna wanna do is say how much you know about elder abuse. I know you know a little bit from the last presentation, but we're gonna learn even more now. And then we'll get around a second sheet and we'll see how much your knowledge has changed. And you will help me fulfill a requirement of my fellowship.
Matt, we don't have sheets.
Okay, so they were over there with the handouts. That's okay, we can get them at the end. So to begin with, some facts. I'll let everybody grab those. Yeah. So just some facts to begin with. Laura talked about most of the actual abuse statistics and all of that, so I'm going to focus more on the diminished capacity stuff. First and foremost, the thing that you're going to see more than anything, I think, is dementia when you're working with older adults. I'll talk a little bit later about how that's really not the only thing that we see, but it is a major source of diminished capacity. So 1 in 3 older adults, meaning people 60 and older, actually die with some form of dementia. And we see about 50% of folks with dementia experiencing some kind of abuse. So this is a particularly vulnerable population. And several people over the age of 65 have even self-reported as saying that they have some cognitive difficulties. And we talked a little bit about the financial crimes earlier, but that's sort of not taking into account medical care and costs of crimes, that sort of thing. So the cost of elder abuse is probably a lot higher than we're estimating it right now. Some additional facts, continue. So I was looking at a great little survey of all the counties in Tennessee, and it's saying that about 9% of adults 65 and older across Tennessee live below the federal poverty line. In a lot of counties, we're seeing closer to 15%. So basically what that's telling us is we have a really, really vulnerable population that we're working with. Let's see. Some of the costs of abuse. So this is on the abuse side of things. So with diminished capacity and abuse, what we're seeing is abuse causes diminished capacity causes abuse a lot of the time. And one of the biggest issues that we see as a cost of abuse is a loss of independence and autonomy, which we'll talk about later as well. That is something that our clients want to avoid, usually at all costs. So we talked about reporting as well a moment ago, and Laura mentioned that there were some ethical components to this. So this is ethical issue number 1. In Tennessee, we're all mandatory reporters. That includes everybody in this room. So if you're somebody that works with people that are abuse victims regularly, there's the question of, do I need to report every single person that has any kind of abuse issue? It's an open question. You know, we have some guidance in the ethical rules, but basically what it's gonna create issues with is attorney-client privilege. And a lot of our clients don't want to report. They might want their issue fixed, but they really don't want to get their family member in trouble a lot of the time. More often than not, the abuser is a family member, and most of those are going to be adult children. So nobody wants to show up at Thanksgiving dinner having put Bobby in jail earlier in the year. They're afraid that's going to separate them from the rest of the family, and that's a huge issue as well. And then there's a lot of action that we can take, and I'm going to talk about that a little bit at the end. But the main thing that we're here to talk about today is capacity, and this is a nice little prayer I like to say. So what is capacity? Basically, it's just the mental ability to understand the nature and effects of one's acts. So when you're asking, does somebody have capacity to do something, you're asking, do they understand the thing that they're doing itself, and do they understand what the consequences will be? So if they're appointing a power of attorney, not only do they need to understand what a power of attorney does, they have to realize what the consequences of that will be. And that's sort of how we are defining that. So the reason that it matters to us is because it's obviously a really difficult issue. We're being asked to identify whether people have capacity or not, but most of us are not mental health professionals. I know there are a couple in here, but most of us are not. And so we're kind of reaching for straws. This is not something that we were trained to do in law school. And beyond just the issues that we have with our clients themselves, even getting the client in the first place can sometimes be tricky. If they don't have capacity to sign a contract, obviously they're not going to have capacity to enter into an attorney-client relationship, which means that we are needing to assess people before we even take them on. And it's not an exact science, and there are mistakes made. I certainly have made some of those mistakes myself. So we're going to talk about some of the things that we can do to protect ourselves, as well as some ways to protect our clients from harm, even if they don't have capacity. And also disclosing information is going to be something we'll speak about. So what actually causes diminished capacity? Like I said, dementia is not the only thing. Just as a part of aging, sometimes we lose certain cognitive abilities as we age. That's normal. But the most common thing that's causing diminished capacity is going to be Alzheimer's, as well as other dementia-causing diseases like Parkinson's or vascular dementia, Lewy body's Alzheimer's, stuff like that. But it can also be other things that present as dementia. So a lot of the times, things like urinary tract infections will actually cause confusion and make it look like somebody does have dementia or diminished capacity in some way when they actually don't. They just need this treated. Also, a lot of mental illnesses can present as maybe looking like diminished capacity. We have a lot of cases of folks with schizophrenia where a family member is wanting to get a conservatorship over them. Having a mental illness does not mean that you have diminished capacity necessarily. It's sort of a separate issue, but it can also be part of diminished capacity. And then things like hearing loss, vision loss can be a big issue. So one of the things, if you have a client who does have one of these disabilities like hearing loss or vision loss, one of the really important things to do for them is get them something to help them with that issue, and it can actually raise their level of capacity. And we'll talk about some other ways that you can raise capacity. And also trauma can do it, whether that's physical or psychological. What we see with abuse victims a lot of the time is that they are going through some psychological issue. Even if it's just financial exploitation, like Laura said, people can be really embarrassed and ashamed about this stuff. It can lead to depression and anxiety, and make it a little bit harder to organize thoughts, that sort of thing. So these are just some basic causes, but this is certainly not the full list. So diminished capacity, beyond creating abusive situations, in and of itself, it can create some issues with things like reporting. One of the biggest issues that we have is causing people to report. I think it's 1 out of 23 cases of elder abuse is reported, something like that. Also just an estimate. But if somebody has diminished capacity, maybe doesn't know what's happening to them, that's going to make it even harder. And then the question may come in, who should report for them? Diminished capacity makes people particularly vulnerable. Like I said earlier, people with dementia are very likely to experience some kind of abuse. Access to healthcare is a big issue. If you can't sign a contract or certain other documents, you may not be able to apply for Medicaid or other benefits. And it can also make you very suggestible. So when somebody's having these personality changes, they may become more vulnerable to being told to do something or another, like Maybe a friend is able to convince them to give them money when otherwise they wouldn't have done that. So the effects of abuse on capacity. So abuse can make things a lot worse. And we'll talk about some ways that there are some remedies for this, but especially routine. If somebody has Alzheimer's or another dementia-causing disease, one of the most important things for their treatment is routine. If something is taking them out of that routine, especially if it's something that is affecting them emotionally, maybe somebody's yelling at them or hitting them, whatever the case may be, it can take them out of their routine and actually make the capacity worse. So removing somebody from that situation may be a way that you can improve their capacity. And then if they have any other psychological or medical problems, those can also be exacerbated. You can think of all the different ways that abuse can affect capacity. So it's sort of this vicious cycle of abuse can create incapacity, or incapacity can create abuse. So more ethical guidance. So when we're talking about what it is that we can do with a client with diminished capacity, when they're maybe not able to direct us to do something, or when they're not even able to create the attorney-client relationship, we do have a little bit of guidance. This is a rule that I recommend everybody becomes very familiar with. The comments are actually really important in this as well. It's pretty much the only guidance that we have as far as diminished capacity issues. So as far as reasonably protective action, we'll talk about what that can be. But as far as the client not being able to give permission, there does seem to be a suggestion in the comments that you can take action without even having the attorney-client relationship. It doesn't actually tell us exactly what that's going to look like. It's sort of, I think, supposed to be on a case-by-case basis. But it's some guidance that doesn't really guide us, unfortunately. Hopefully we can do something about that in the future. So there's going to be some implied authorizations to carry out your representation with somebody with diminished capacity. So really important rules for that are 1.6 and also the diminished capacity rule 1.14. I think mostly the implied authorization to reveal attorney-client privileged information is going to be mostly in the courtroom, but this is also something you think about outside of the courtroom. So if you need to do something like report, this is the rule that protects you, kind of. So if there's a really serious situation and you need to go ahead and report to the police or to Adult Protective Services, then this is what gives you the authority to do that. And I really recommend if you are using this implied authority to keep a good record so that you don't get yourself in trouble. But the rules also say that the position is an unavoidably difficult one, which, you know, that's true, but it doesn't really help much. Now, another thing that we're doing when we're working with elderly clients is working with third parties a lot of the time. It may be a child that's bringing them in to get a will done or power of attorney done. And that's okay. They can have a family member or somebody else present if they want. Under these rules, that is okay, but you want to try to meet with them alone if at all possible. Unless they're just absolutely refusing to meet, you're going to want to meet with the older adult alone. The reason being because there could be some influence from that other person when they're in the room with the client. Plus, we can't protect the privileged information if a third party has that information as well. But sometimes a family member or another person may be necessary for communication or for helping the older adult understand the issues. One case that I had, we had a lady who had a stroke that caused her to have a really bad stutter. It was so bad you couldn't understand a word she said. And there was just nothing to do except to have her communicate through writing. And if we needed to get something from her right away, then one of her children would have to relay that information to us. But in all cases, if you are working with a third party, your client is always the first person you think about. No matter what they're telling you to do, you're going to want to find out what the client wants, what they would do if they were able to make the decision. Any way that you can to enforce your client's decisions, that's what you got to do. And also when you are doing especially things like appointment documents for agent appointments, you need to ask yourself who the client is. Who am I really helping here? If an adult child wants to come in and say, you know, I really want to protect my mother's assets, so that so that when she dies, I'll get them. Well, that's something that they're benefiting from, not the client. So that's something to look out for. And then, like I said, attorney-client privilege can be affected by the presence of third parties. And that's something you should always advise your clients on if they insist on having someone present. So what do all those rules really mean? In 1.14 and 1.6, the best thing that you can really do is use your best judgment. I mean, there's really no exact science to this, but you do want to do everything you can to protect yourself in case some decision is questioned down the road. So create a really good record showing your decision-making process. We'll talk about some ways to do that as well. Contact the Tennessee Ethics Commission if you have a question. I've done that on at least 3 different cases, and I feel a lot more secure about my decisions if I ask the people that would be judging me if a complaint was brought. And then there are some organizations that will do case consultations. I find justice and aging to be really, really helpful. All 3 of these that I've listed have really great webinars all the time. And Nickler has a case consultation form that you can fill out, and they'll help you kind of work through the issues. So if you're having an issue ethically, the best thing you can do is ask for help. So what is the legal capacity standard? It's a good question. There's not actually a standard for capacity. It's going to be different depending on what the issue is. So like I said before, capacity is just the ability to understand what you're doing and the consequences thereof. So if you're talking testamentary capacity, you're talking about, do they understand that a will is going to leave certain things to certain people, and do they understand what the consequences might be of leaving that stuff to certain people? Same with giving gifts, contractual capacity, and then I have decision-making capacity and functional capacity here. That's something that's really important when we get to conservatorships, which we'll also be talking about. So how do you determine capacity? This is the biggest issue for us. If you have a fear that there's diminished capacity, and really if you're working with older adults, you should always assume that they have capacity, but you should always also be ready to examine that assumption. So what I think is that if you can, you always get a medical opinion. That's not something that's always going to be possible. It may be financially not possible, or maybe the person doesn't have transportation at the time when you're evaluating them. Whatever the case may be, we do have some tools to evaluate clients on our own, but it's going to be on a case-by-case basis. Yes?
I've asked about doctors and nurses, and they'll say, well, that's a legal definition.
Sure.
And they won't always go there, because they'll say, you're the lawyer or whatever. They don't always like to go and say capacity and no capacity.
Sure, and I've had that experience where some doctors are more willing to help on that than others. Especially if they're in a nursing home, though, I think the staff is a lot of the time really eager to help that person, and will kind of help you out with that. But it's true, they have different standards, and I'm going to talk a little bit about how our evaluations differ from the medical evaluations, because there are certain, like the mini mental status exam, if you're familiar with that. So that's a medical standard. That's not really something that we should use because it's not a legal standard. But I have a slide on that, so we're going to get to that. I think it's actually the next one. So more often, we're not actually legally determining capacity. We can't say this person for sure has capacity or not. The only people that can do that are doctors and nurses or judges. So if you're going to court to determine somebody's capacity, that's going to be the judge's decision. We're determining level of capacity specifically for working with that client, but that's not going to be legally enforceable. That's more opinion than anything. And once again, functional and decision-making capacity become very important when we talk about some remedies for abuse. So determining capacity for representation. So we do have some guidance on this, and I really encourage you, if you have any kind of fear that the person does have diminished capacity, you use these tools. So the Aging Commission through the ABA has a capacity worksheet for lawyers. That's what it's called, is capacity worksheet for lawyers. I have the link in here somewhere, but it's a pretty general, like, how are they responding as far as memory and orientation, space and time, stuff like that. It gives you space to take notes in the margins. and at least put down on paper why you think this person does or does not have capacity. And I always include that with our retainers. I try to put those right next to each other. So what are you going to do if you do determine that capacity is diminished? There's some stuff that we're going to talk about on that later, but first and foremost, if the person has diminished capacity and they're experiencing some kind of abuse, you just have to direct somebody to report if they can. I think that's usually the best suggestion, since we are a mandatory reporting state especially. So some other challenges that we as legal professionals have, this is something I'm curious about. How many people in here are from an urban area? Okay, keep your hands up. How many of those people have lived in a rural area as well? Okay, so a good bit of you, but some of you have not lived in a rural area. So there's definitely some implicit biases when you're going from one setting to another. I certainly had this myself, and sometimes, you know, just the culture will sometimes make you think that maybe somebody's not entirely with it. I think I have a really good one that Kathy and Ashley know well, where I actually had somebody speak to me in tongues when I assessed them for capacity. That didn't mean that she had diminished capacity. She just was she was a believer. So that will happen, and that should not lead you to believe that that person has diminished capacity necessarily. You just need to look at whether or not the reason you're thinking that is because of some kind of cultural bias, or because maybe you have some sort of ageism. There's a lot of really young folks in here who, you know, a lot of the times we think of older people as starting to kind of lose their cognitive ability, but just because somebody is elderly does not have anything. I don't mean that in an insulting way at all. Sorry, I'm trying to phrase this good. But then there's also the, yeah, no advanced age yet. And there's also the lack of context. You know, maybe somebody doesn't have the, you know, stopped education at maybe like the 3rd grade or something like that. It doesn't mean they have diminished capacity. That means they're uneducated. So that's important too. You should not just base your evaluation on what you're seeing from the person in front of you. If you can get any context, that's really important. And the issue might also be, like I said earlier, it might have something to do with a different impairment that you can actually fix. If somebody's got a problem with hearing aids, then getting them new hearing aids might be enough to raise their capacity enough that you can then represent them. Whereas if they couldn't hear you before, then maybe it was going to be impossible. And also, difficulty communicating does not equal diminished capacity either. I've had a number of clients that are non-communicative, and that doesn't mean that they're not able to understand what's happening. That just means that they need a different way to communicate than other people. And we'll also be talking about some ways to support that communication. Now, as far as, so I guess we're skipping around a little bit, but the capacity worksheet is not the only assessment tool we have. Within 1.14, the diminished capacity rule, we have a little bit of guidance. So this is another thing that you can make this list and write down each thing. You know, appreciation of the consequences is really important. Whether or not what you're doing is fair to them or somebody else, whether what they're doing is consistent with what they would do if their capacity wasn't diminished. And now in something that's not in the comment, but is recommended to evaluate is whether the decision that they're about to make is irreversible or not. If it's a power of attorney, they can revoke that pretty easily. Hopefully there will be no harm done if they made a bad decision as to who the power of attorney is. But then if you're maybe transferring property to somebody, well, that's going to usually be irreversible. The person's probably not going to want to give the property back. So you want to be more cautious in cases like that, I think is what that's saying. Like I said, if you can get a clinical assessment, then absolutely do that. In conservatorship cases, you're going to have to do that. And then if you have medical staff at your firm, then you should use social workers and medical staff and really trust their expertise, because they're the ones that are trained to know this stuff, not us. So we're depending on other people a lot. So it's good to have those relationships. If you don't have somebody in the office, it's good to have somebody that you can talk to about this. Like if you know a medical professional that will give you some advice based on some you know, symptoms that you're describing, that may be really helpful. So relationship building is really important as well. Like I said, there's some ways to enhance your client's capacity, but there's some really simple ways when you're actually meeting with the client that can enhance their capacity. Number one, ask them, if you're gonna meet with them, ask them what time of day is gonna be best for them. If they're best after breakfast or something like that, then that's when you need to go meet with them. If they're better around like 3 in the afternoon, then that's when you should be meeting with them. Make sure everybody's hydrated. Dehydration can also look like dementia. And when somebody does have dementia already, maybe they're forgetting to do things like eat or drink. So that's something really important. Just offer them water. Also with some of the older clients, especially in some of the rural areas, we're seeing some issues with making people comfortable with us. You know, getting them to the table in the first place might be a big issue, but making sure they're in an environment that's not going to scare them, that could raise capacity. And you just need to craft the interactions to what's going to work for them. If there's some kind of context that you can get from a family member or something about maybe, you know, what room would they be most comfortable in, or what kind of lighting would they want, then that's what you need to make happen in order to raise their capacity as much as possible. So that's all the basic evaluation business. And so now we're getting to what we actually will do with this information. Another nice little comment there. So as far as legal proceedings, we are addressing diminished capacity in court in every case. If there's diminished capacity, there are some accommodations for that in every case. This isn't just conservatorships where you're determining capacity. I have a case right now, a divorce, where one of the parties has an attorney ad litem because he is incompetent. And that's important to make sure that people's rights are being respected in that sense. If you have somebody who has diminished capacity in a court case, there's a lot of things you can ask the judge for to help them. You know, there's a lot of accommodations for all kinds of disabilities. If being in the courtroom is going to cut into a person with dementia's routine, then it might be a good idea to have them testify remotely. You can even do a deposition with them before you file. I think there's a new statute about filing depositions for somebody who might lose capacity. I'm not exactly sure what it is, but it's a really good way to preserve the testimony. A lot of the times we'll see in criminal cases, the victim may die if they're elderly, and then the abuser will never be convicted for that reason. So we want to make sure that doesn't happen. You can ask the court for guidance. If there's an issue you just have no idea how to deal with, then ask the court. Don't try to assume any of this. The worst thing you can do is just guess with any of this. You can mess things up really bad if you just guess. So if you need to ask the judge what they would do in this situation, then make a motion asking them what you should do. I've done that and it's been helpful. So as far as guardian ad litems and attorney ad litems, does everybody know what those are, attorney ad litems and guardian ad litems for the most part? Okay, well, so a guardian ad litem can actually be appointed in any proceeding at all, and potentially an attorney ad litem as well. The guidance for that, it seems to be that if somebody is determined to be incapacitated, that will be the triggering factor for asking for a guardian ad litem and having them be appointed. But there's no really clear guidance on that. It's really in the judge's discretion more than anything. And if the guardian ad litem is the person investigating any case, they're not actually representing anyone. If the guardian ad litem says this person, their capacity is too diminished for them to represent themselves or to hire an attorney, then the judge can appoint an attorney ad litem based on that recommendation or just on their own as well. So if you think that there's a need for a guardian ad litem, just ask for it.
How do you pay for this?
It's a really good question. So, you know, with our clients, a lot of the times these people just aren't going to get paid. There's just no way around that. But what we remind those attorneys that are taking those cases is the fact that this person doesn't have any money, doesn't mean they shouldn't be allowed to be in court. I know that guardian ad litems are compensated in juvenile cases. So I'm not 100% sure what the issue is in adult cases, but as of right now, there's no mechanism for the AOC to pay them. The costs for this, especially in conservatorships, will usually be charged to the person with diminished capacity. Usually that's because they're institutionalized, and they're only going to get that $50 a month, but maybe $10 a month is going to go to the attorney, something like that. But honestly, what we tell them is that it's pretty unlikely that you'll get paid. I know Mal's does this, and something that we're wanting to do is we will accept appointments for guardian ad litems or attorney ad litems, and that way that doesn't become an issue. It can be really dangerous if the attorney's not getting paid. If they really don't want to do it because they're not getting paid, they may not represent that person's interest very well if that's the case. So if that's something that you handle like conservatorships or anything else like that, going to the courts around you and letting the judges know that you'll take that appointment is a good idea, yes.
I was going to say too, we've been able to create a Chinese wall. We've spoken to the ethics commission on this, and we've accepted and used our pro bono project to bring in attorney ad litems and guardian ad litems in cases, and that's been a better way to do it as opposed to the judge telling somebody, you're going to have to do this and you're not going to get paid at all. At least they're volunteering and have a choice in the matter is what said the other way.
And then you can waive it too.
Sure.
So
Well, the
there's
judge
some
can waive
cases
it.
where the judge is adamant that we gotta have
And I get that.
Especially in cases of abuse, especially when it's family infighting that's happening, you just can't do it without a guardian ad litem.
And Matt, remember, the judge has the authority to assess costs,
Right.
including the GAL cost. So the petitioner could end up paying
Sure.
GAL as well.
I think the only situation where it's mandated is an attorney ad litem in a conservatorship is supposed to be paid by the respondent or the ward. But that is not always followed. It's really up to the judge. And that's something you have to counsel your clients on when they're wanting to file something is you may get hit with these costs at some point, and there's really nothing that we can do to stop that. Obviously, we'll do everything we can to avoid those costs, but it's just a part of these proceedings that they're expensive in nature. And that's because it's a person's rights that are on the line, and it's a good thing. But we do need a payment mechanism, which we don't currently have. So what are some common causes of action that do involve diminished capacity? So these are mostly ways that we address elder abuse. There's a lot of options, obviously, but I think these are the main ones that really involve diminished capacity. Is everybody familiar with the Adult Protection Act, Order of Protection? I know that I talked with some folks in the Taos Family Law Group about this. This is a relatively new statute. It's specifically for adults 18 and above who have diminished capacity such that they're not able to file something themselves. A family member, and only a family member, and I think it's immediate family member, has standing to file these. It's a lot more broad than regular order of protection. You can actually prohibit someone from providing care. You can lock somebody out of a bank account. So this actually can protect people financially, whereas the other order of protection is not usually going to be able to do that. And it's usually a little bit easier to get. One case that I was successful in was a case where a woman with dementia, very advanced Alzheimer's, had a granddaughter who was on, I think, probably meth. She would come into the house at 2 in the morning and scream at a different member of the household asking for money, but it woke up the mother and the grandmother. And like I said, if her routine is impacted, then that can severely affect your health. So we got an order of protection for her to keep the granddaughter from doing that and to let her age basically in peace where she wants to age, which a lot of the time is the goal. And these are very good things to use. The one thing to keep in mind is that you will need to notify Adult Protective Services that you file these and give them an opportunity to intervene. They usually won't. In fact, you're usually only filing these if APS didn't intervene in the first place, but that is a requirement. And then there's conservatorships, which I definitely want to talk about a good bit. I think I have something just on conservatorship, so I'll get to that. Yeah, I've got a little bit about all this actually. One thing that I do want to mention is with the Adult Protection Act right of recovery, this statute gives you a right of recovery in any abuse situation or financial exploitation situation. I've seen cases where somebody's alleging nursing home medical malpractice or something like that, and there's caps on that, obviously. So one case that went to the Tennessee Supreme Court, they said that the correct action to file was the Adult Protection Act lawsuit, and they could recover for essentially malpractice through that, or through a basic negligence action. That's going to establish your negligence per se with the duty and breach. And then there's also a number of administrative actions. I like to mention that because I think a lot of people don't know that the Federal Trade Commission or the Federal Communications Commission actually have an adjudicated process when you have an issue. We filed an FCC action before for a phone scam, and we were able to recover on that without really too much effort either. It's very simple to do, and it's a very good way to rectify the situation, I think. So, conservatorships. So I talk about this first, but honestly, this should always be the last thing that you think of. This is not something that we want to do. If we can avoid it, then that's the idea. Because what this does is it literally removes somebody's rights to make certain decisions in the least restrictive manner. But really, if you're removing somebody's rights, that's pretty restrictive anyway. And it literally gives those rights to another person for them to use. There's a little bit of confusion, especially if you're from a different state. You might know these as guardianships. A lot of other states call them guardianships, but for this state, guardianships are specifically juvenile proceedings. I have a bit of a list of pros and cons of conservatorships. It can be a really good tool to end abuse, especially if somebody who is completely demented, has no ability to make decisions anymore, is being taken advantage of for that, and they don't have somebody that they've appointed as their decision maker. This is a lot of the time going to be your absolute best choice. It can cancel former agency relationships. It can stop somebody from continuing to make bad decisions. It can a lot of the time lead to improved quality of life, especially if that person needs to be institutionalized for any reason and isn't able to do so themselves. Of course, some of the problems are that you are going to lose some rights here. And then the person who is the conservator has total control over those rights. And you just hope that the judge appointed the right person when that happens. If it's, and you do have to notify the entire family, the entire immediate family is entitled to intercede in these proceedings. So you're bringing in everybody. You don't know that family's relationship. If there's 10 siblings or something like that, that can get messy. So you might want to avoid that. And this is also, conservatorship is a word that scares a lot of our clients. This is something that they want to avoid at all costs. A lot of the education that I do is about how to avoid ever ending up in this situation, despite the fact that you think that this is never going to happen. So yes, so the case that you really need to know about if you are doing conservatorships is in the matter of the conservatorship of Groves. This is a really important case if you want to do these. It gives you basically the standard for how the conservatorship is going to be split up. So you're going to consider decision-making capacity and functional capacity in any conservatorship situation. And those are exactly what they sound like. Decision-making is the ability to make and communicate any decisions, and functional capacity is the ability to perform the basic activities of daily living. Usually we're addressing decision-making capacity, but if the person doesn't have decision-making capacity, more often than not, they're not able to take care of their activities of daily living as well. But this is how we get into the least restrictive portion. The judge is going to just look at what needs to happen in order to rectify this specific situation. So if the person is able to make medical decisions, but is having trouble managing their finances, then the judge is only going to grant a partial conservatorship. And that's what you want to do. We want to try to get these to be as narrow as possible if we're doing them. Usually we're going to see full conservatorships when it gets to this point, but if possible, you want to only ask to remove certain rights. It says in the statute which rights you can have removed, so I encourage you to look at that as well. So yes, okay. Now that is the regular full conservatorship. If we're in an emergency situation where somebody is in the process of being abused or is facing irreparable harm for any reason, then an emergency conservatorship might be the right way to go. I've only done this once. We were able to get the emergency conservator, but in the end, there was the determination on capacity was that the person did have capacity, but the emergency conservatorship is not about that. The regular conservatorship is where capacity is determined. The emergency is just if there is something that is obviously going wrong that makes it kind of look like they have diminished capacity maybe. You're gonna have to have a hearing on this within 5 days of the appointment, and the judge doesn't have to make this appointment, but they can. And then there's a 60-day limit with it. You can only have these for 60 days, and then you have to go ahead and file a full conservatorship petition or just drop it. And in this case, you don't have a choice. An attorney ad litem is always required because this is a pretty extreme measure. You should really only be using this in the most extreme circumstances. The way we used it was in a sweetheart scam. The lady had lost, I think it was like $200,000 or something, and was trying to sell her house and send the proceeds from that to the scammer. So we were able to prevent her from doing that. So it worked. We ended up getting a full conservatorship. There was no diminished capacity in that case. I actually think it's a really good example of when it looks like diminished capacity, but it's not. The woman had just lost her husband, and when you see that situation, a lot of time they're looking for any kind of human interaction, some kind of comfort. So she found a guy online who took her for $200,000. Adult Protection Act, order protection. I already talked about this a little bit. Really good tool, especially while you're pursuing a conservatorship or something else like that. A big difference with the order protection is the length. You can only have this for 120 days to begin with. You can ask for an additional 120-day extension, but it's really not supposed to go beyond that. There are no forms used by the AOC right now, but I have created some. So if any of y'all are trying to do this, just let me know and I'll send you the forms. The order protection forms that we have now, they just don't make sense with this statute. There's no place to have like, this is the person filing on behalf of this person. So it makes more sense to the judge if they see it in the form that complies with the statute. Then I also want to talk about undue influence and coercion. A lot of the times this is going to come into play with declaratory actions. So think about a property transaction, for example. The standard is actually in the Groves case as well. That actually did involve an undue influence issue. This is hard to prove. This is not something that you're going to win on too terribly much. What you're going to need to prove is that the person was in an inferior position of decision making at the time that the decision was made. That might be that the person who got the benefit of the transaction was a caregiver or somebody in a position of power, like an accountant, maybe who's like handling their taxes and whatever the case may be. A lot of the times it's family members. But what you're looking at is just basically who is in a dominant position. If it's a fiduciary, more often than not, that's going to be considered a dominant position. There are also these semi-fiduciary relationships. What that means basically is if it's a family member that this person is relying on to make certain decisions. The example I think that I've seen is a son who was giving the father all sorts of financial advice for years and years and years, and then used that to his advantage. So that was a semi-fiduciary relationship because he was relying on him for financial advice. And there's some extreme vulnerabilities to this. The one that I just talked about, I mean, the sweetheart scam, that was an absolute undue influence issue. The fact that the lady was isolated, had just lost somebody that she had been married to for 50 years, whatever it was. These can make a person a lot more vulnerable to undue influence, and that's the kind of evidence that you're looking for, is what vulnerabilities they had at the time. That's how you're going to prove that. I can't say that I've had any undue influence actions just because they're so unlikely to succeed. There's usually a better option, but it is out there. So the final thing that I want to talk about is what we do before we ever get to the point of needing to get to these actions. So most of y'all are probably familiar with supported decision making. It's essentially just the theory in disability and elder law that decision making is kind of a fluid thing. We want to do everything we can, obviously, to protect our clients, but at the same time, independence is so important to them. And it should be to us as well. So it's really this push and pull between autonomy and protection. So we have some tools. Obviously, powers of attorney, other agent appointment forms. SDMA here this is the supported decision-making agreement. This is a brand new thing that was just passed this past legislative session. There's a foreign for it in the statute itself. It's more or less a power of attorney. What it does though is basically the supported decision maker can get access to whatever confidential information. They can gather that information, they can communicate it to the person with a disability, and then they can help communicate that decision to whoever needs to know the decision. Of course, the problem there being, if they're the ones communicating the decision, how is it that we know that that's the decision the person with the disability made? But we will see how that works out. The idea is to give the person with the disability more decision-making authority. Whereas with the power of attorney, you're giving away some of those decision-making powers, especially when somebody loses capacity. Then the power of attorney is going to have a lot more decision-making capability for them. It's actually not, I have it somewhere, but it's actually not on Westlaw or anything like that just yet. It has not been added. Oh yes, it's 34-1-101. And I'm going to get to that in a second as well. But yeah, it's very, very new, but it is signed by the governor and ready to be incorporated. Supported decision-making is such a broad thing. Really anything that you're doing to help somebody plan for their future and help them make decisions now rather than later, that's supported decision-making. What I always tell my clients is you just don't want to end up in a situation where your decisions aren't being respected just because you didn't plan well. And more often than not with abuse victims, we are seeing they did a poor job planning. So especially when I'm doing any kind of community education, this is something I talk about a lot. And I put limited conservatorship in here. We've used a limited conservatorship in the past, a voluntary one, to help end some ongoing abuse. The reason that might be better than a power of attorney in certain circumstances is that it is irrevocable by the person who has the conservatorship. Like if they're suggestible already, then the person who's abusing them is probably going to be able to convince them to revoke their power of attorney. So that's where that might be helpful. Not something you do unless you really examine the situation. That's the best idea. We also have, for supported decision-making, another ABA tool. It's called the practical tool for lawyers. In all cases where there's diminished capacity, you're always going to want to go ahead and presume that they don't need a conservatorship. And if there are any reasons for concern, you're going to want to clearly identify them, figure out how to address them. I highlight community and team here because a lot of the time what we're doing is helping them to gather some kind of support network. You know, maybe there's family members who didn't know what was going on but really want to help. Maybe there's community resources that the person doesn't know about that would help before any kind of decision-making is taken away from them. I think one example would be like if somebody's having housing issues because they can't afford the utilities, but they don't know that there are programs that can help pay for the utilities, you know, helping them identify things like that. And then getting a team in place for them. A lot of the times with supported decision-making, it really is a team effort. The client themselves is gonna help you identify people that they know and trust. Maybe they don't have people they know and trust, which is important to know as well. And you can get people like the public guardian involved, whatever the case may be. But these are just things to think about when you're first trying to identify the issues that your client with diminished capacity is having. And then least restrictive alternatives. So this is also in the statute with supported decision-making, with the supported decision-making agreement. So this is the definition they came up with. This is the first time they've actually added this definition for supported decision-making. There's not really a lot to it. It's sort of hard to define. It may be a legal thing. It may be emotional support, whatever it may be. There are usually going to be alternatives to taking away somebody's rights or you know, committing them or removing them from the home that they wanted to age in. And what it's telling us is that we want to use the really restrictive options only in extreme cases and as a last resort. So I've got a little bit now that is maybe not super on topic, so I'll pause and ask if anybody has any questions. I know that was quite a lot.
Do you counsel the fiduciary about what they're actually taking on? Because yeah, actually, mom's great. I mean,
Yeah.
The reality of what you're doing.
It is very important to do that. I do that. I don't think I did that enough at first. A lot of the issues that we have with like a power of attorney is because they didn't understand what their responsibility was. And a lot of attorneys won't do that. They won't explain to that person what's going on. One thing that I think is helpful, and the supported decision-making agreement has this, is an acceptance of appointment that actually lists their rights and responsibilities. And there are forms for that for powers of attorney, but you know, a lot of times it'll just say all the powers that this statute gives you, but nobody reads the statute. So you do need to counsel them on what they're doing to keep them out of trouble and make sure that the decisions of your clients are going to be respected, because that's what it's about. If their decisions aren't being respected, then the thing that you did was kind of pointless. Yeah.
I just want to tell everybody, Matt's written some pretty good op-eds for lay people, and one is on supported decisions, and I'm sure he'll be glad to send that to you if you'd like to use that as basis for a handout.
Thank you. Do you have a question?
I had a couple of questions about conservatorships. One is, someone may come to you seeking you to represent the person who's the subject of the conservatorship. But if you're doing the conservatorship, that person is not your client.
Correct. They're the opposing party.
To become conservator is.
Mm-hmm.
How do you sort that out? And
That's a great
do you
question.
look at the income of the person actually seeking to be the conservator and determining whether to represent?
So that second one is a little hard to answer because my program doesn't technically have an income limit, and in a situation where somebody is an abuse victim, we're supposed to kind of do whatever needs to happen to get them taken care of. But as far as representing the petitioner or any other third party on behalf of the older adult, what I do is I have a conflict form. I say that my program is about helping this person, and that's an inherent conflict sometimes. And you know, that's just revealing to the client what the conflict may be and having them be fully informed in writing that may happen. And I always have, especially family members, I have them sign a conflict form, because we have had issues in conservatorship cases where the adult child wanted something that was clearly against what the older adult, well, what was, you know, in that case, it was something that could have medically harmed them. And I didn't have anything to fall back on in that case. So that conflict form is a great way to do that. You might want to create your own. I can certainly send out the ones that I've made. But that's how I cover that.
Who's your client?
The petitioner is going to be your client in that case. So yeah, it is an ethically dubious situation, but when your entire job is around preventing abuse and that's the only way to do it, you just kind of got to finagle it a little bit. You know, it's the point of the conservatorship anyway is supposed to be for the benefit of the respondent. So I don't think that there's anything particularly wrong in doing that. And the best of your ability, you're still going to try to do what your client is going to want to do. But if it's going to be something that harms the ward, you know, they need to know up front that that's a problem. They should know that anyway, but it's good to spell that out. It's a really good question. It's been an issue before.
The other issue I had is the cost for a guardian ad litem. I know the statute allows the judge to waive that in our jurisdiction, and I think most jurisdictions, the judges will not. Will require a guardian ad litem. How do you deal with that cost?
Yeah, so we do ask a lot of the time for it to be waived, especially if it's a simple case where there's not a ton of family members involved. And we've had some success with that, but it's unavoidable in cases, especially where there's a lot of people involved. The cost is, you know, it's not really supposed to be an object, and that's all that we can really say. You know, this person needs to be able to have access to court in order to protect their rights and their physical well-being. The cost isn't really our problem. I feel bad to say that to private attorneys, especially when we're trying to get them to help us out all the time, but there's just not a mechanism in place. What I'll say to them is, you know, if you want a payment mechanism, you should really talk to your legislator about that, because we certainly can't do that.
So the judge will appoint a guardian ad litem, and if there is no source for payment, the guardian ad litem is out of luck.
Yeah, usually. But, you know, it might, like I said earlier, it might be something where the person is paying a very small amount over time, and that's the best that they can do. But a lot of the times it is, you're just out of luck, and, you know, they're just getting brownie points with the judge in that case. It's not great.
I was gonna ask, is that something, obviously I'm in Shelley, so we're huge, but is that something that is a problem across the state? Because generally what has happened, at least for my county, I've gotten calls tons of times from attorneys prior to filing a petition that say, look, my client doesn't have any money, are you willing to serve as a guardian?
Right.
And they will just provide that recommendation.
So that's a good way to handle it for sure. We just haven't had a situation where we've been appointed on any of those cases yet. A lot of judges don't know that that's an option, so you really got to inform them that that's an option whenever you get the opportunity to do so.
We used our pro bono, mentioned that earlier, we used
Right.
our pro bono project as a way to pull in a private attorney who willingly want to provide that service free of charge, as opposed to being forced into a situation of providing pro bono and not knowing it on the front end.
And a lot of us who practice, I mean, I'm only in probate court, most of us have no problem accepting that data all the time. So that's why I asked, I mean, I assume that would be a lot different in the smaller county.
Yeah, it's a big problem.
Yeah, there's not a huge pool of attorneys to choose from in certain counties, so it has been an issue in the past.
And the clerks have been very protective of the private
Yeah.
attorneys in some of our rural counties.
You mean their cousins?
Left that kind of as a barrier to the court for our clients.
And I will say, in our rural county, our judges are being weighted. So I know residents doesn't happen, but for our clients, it's never been.
It's very dependent
I mean, it's
on
clear,
the
you
county.
look at it, they have commission order, you do the most, all that stuff. But I've never had a judge force me to have, when I've asked for it to be waived, I've never had it refused in any of our settlements. So,
And there's also a bond issue in some counties, because some judges will require bonds.
And counties, we can get that away, 'cause most of them.
Yeah.
don't want that.
Shelby County, I think, actually requires them, if I'm not mistaken. Yeah. Especially if there's not a lot of property, you can do that. That's sort of getting into the nitty gritty of it, but yeah, there's a lot of ways you can avoid costs, but there's just sometimes when it's just not avoidable, and you don't want to, you know, give that person or take away from that person's rights just because they're having trouble paying for it, you know. It's certainly an issue.
Talk to our petitioner about as well, because our client is the petitioner when we're filing conservatorship cases, and that's something that we go over when we go through our retainer agreement with them. But sometimes the court will assess the costs of the attorney ad litem and the guardian ad litem against the petitioner, and we make them very aware of that on the front end, so that they know that if they go forward with this, that is a possibility on the back.
Yeah.
So they can be responsible.
We've had a lot of people not want to move forward because of the potential cost.
And AOC is very aware of this issue, and it is an issue that we keep bringing up to them. So we are starting legislative sessions over now, so we're starting meetings with different agencies that we do every summer, and that is one of them. And the whole issue of guardianship, conservatorship, public guardianship, and payments and fees, and that's on the agenda. So I can say that they're very aware. I don't know if changes will be made statutorily, but it is something that they are aware of and are being reminded of. So.
Okay, so it looks like I am out of time. Those sheets that I had y'all fill out at the beginning, if you would just pass those to the side and then up, then I'm gonna have to have y'all do a second one to show how much y'all have learned now. So if you would pick up another one on the way out, or I can hand them out, whatever is gonna be fine. Yeah, this will be very helpful to me.
And the supported decision making, you just want to mention that, it's public chapter 605, if you wanted to look it up. It did become law, and it is signed into law. It's a very reduced bill from what it was, but
Yes.
it is public chapter 605.
They did their best. Okay, thank you.